Look, you send a check every single month, you live in the house, and you probably have a giant mountain of paperwork from closing just shoved in a drawer somewhere. But if we stop and ask the fundamental question, the one that causes just so much anxiety in real estate, do you actually know who holds the power? Like, who actually owns your mortgage? Well, here's a massive hint. It's almost certainly not the bank. And what's wild about this is that when things go sideways, say a missed payment or a weird escrow dispute, everyone immediately blames this vague, monolithic enemy. We all just say, oh, the bank made a mistake, or I'm fighting the bank. But in legal reality, the bank is a totally meaningless term. It's a catch-all phrase, and honestly, it actually prevents you from understanding your own legal rights. So, welcome to this explainer. Today, we are going to methodically untangle this super complex web of entities involved in your mortgage. We're skipping the internet rumors and the wild social media legal theories, and we're looking just at the actual legal documents. Our goal here isn't to create fear, it's to give you absolute crystal clarity. Okay, here's our roadmap for getting that clarity today. 1. The myth of the bank. 2. Note versus security instrument. 3. The cast of characters. 4. Transfers and assignments. And 5. Defaults in foreclosure realities. Let's dive in. All right, Section 1, the myth of the bank. Stop collapsing the roles, because practically all real estate confusion starts when people blend distinct legal roles into one single word, the bank. And doing that immediately leads you to demand the wrong documents, or worse, sue the entirely wrong entity. Moving right along to Section 2, note versus security instrument, understanding the paper. Okay, so before we can introduce the people, we absolutely must understand the paper. This is our core principle. First, you have the promissory note. This is simply your written promise to repay the money. It outlines your interest rate, your payment schedule, what happens if you default. It's the debt obligation itself. But here's the catch. The note is not the public title record. For that, you need the security instrument. Depending on your state, this is often called a mortgage, a deed of trust, or a security deed. Think of this document as the physical bridge connecting your promise to pay directly to your physical property. You just cannot analyze a mortgage dispute without separating the promise to pay from the bridge that actually secures it. Which brings us to Section 3, the cast of characters. Who actually does what? First up on the roster is the servicer. Now, this is the company you probably know best. They're the ones managing your loan account day to day. You make your payments to them, they send you your periodic statements, they manage your escrow account for taxes, and they handle loss mitigation if you ever fall behind. But, and this is absolutely critical to know, the servicer may or may not actually own your loan. Very often, they are literally just an agent acting on behalf of someone else. Then, lurking in the background, we have the investor. The investor is the party or entity that actually owns the loan or holds the underlying economic interest in it. This could be a government-sponsored enterprise, some securitized trust, or a private fund. And what surprises most people is that the investor might not actually appear on your monthly statements. They might not even be filed in your county land records. But don't let that fool you. Their hidden nature doesn't mean your obligation is somehow void. It simply reflects the normal, albeit super complex, structure of modern mortgage finance. Now, depending on your state, instead of a traditional mortgage, you might have signed a deed of trust. And if so, enter the trustee. This is a third party specifically named in the security instrument. If a default occurs, this trustee is authorized under both the deed of trust and state law to potentially conduct a non-judicial foreclosure sale. They hold a very specific power of sale outlined right there in the paperwork. Okay, people got horribly confused here, so we really need to clear this up. A deed of trust trustee enforces a security instrument in real estate. A private trust trustee administers a trust fund for a wealthy family's beneficiaries. It is the exact same word, but a totally different universe. The entity foreclosing on a house is not managing your family estate. They are literally just a mechanism for real estate security.
And finally, we have the notorious MERS, which stands for Mortgage Electronic Registration Systems. MERS often pops up in county land records as a nominee for the lender or as the mortgagee of record. And man, when people see MERS, they jump to extremes. Some assume it means everything is perfectly fine, while others are absolutely convinced that the mere presence of MERS automatically equals massive fraud. Look, both assumptions are just lazy. MERS's actual authority depends entirely on the specific language in your mortgage document and the case law in your specific jurisdiction.
So, putting all the puzzle pieces together, we have this entire ecosystem mapped out. Borrower, lender, servicer, investor. When you break it down by their specific source documents and functions, it really reinforces our golden rule for this explainer. You must identify the specific role and the specific document before making any legal assumptions. Because if you don't know who signed the note versus who is listed on the security instrument, any legal argument you try to make is just going to fall completely flat. Section 4. Transfers and assignments. When the loan moves. Because the mortgage ecosystem is definitely not static. Notes get endorsed, servicing rights get sold, and mortgages are constantly reassigned. Each one of those changes has to be tracked carefully by document, by law, and by role. Which brings us to our final section, Section 5, Defaults and Foreclosure Realities. Time to bust some myths. When things go wrong and a default allegedly happens, desperate homeowners so often fall victim to fake law. You've probably seen these internet guru myths spreading like a wildfire online. Show me the wet ink note or I get a free house. Or, they securitize my loan so my debt is completely erased. Or, my favorite, there's a gap in the assignment chain so I own the home free and clear. Listen to me, these myths are incredibly dangerous. Walking into a courtroom demanding a wet ink note because you saw a guy yelling about it in a YouTube video, that will instantly destroy your credibility with a judge. Now, yes, there are absolutely real issues in mortgage enforcement. Sometimes assignments are defective or servicer lacks authority. But you can only fight those battles with actual, factual legal analysis, not fake law mythology. I want to leave you with this incredibly empowering principle directly from our source material. Before you challenge enforcement, identify the instrument and the role. Always separate the roles. Are you dealing with the servicer, the investor, the trustee? Always demand clarity over mythology. Because think about it for a second. If you don't even know who holds the paper or what specific role they play in the life of your loan, how can you ever expect to successfully protect your own home? Keep asking the right questions and keep demanding the facts. Thanks for joining me for this explainer.